Good morning. Please be seated. We are here for oral argument on Industrial Park Center versus Great Northern Insurance. It's our number CV-25-0330. Certified question. You have each side. You each have 20 minutes. You may reserve whatever time you wish for rebuttal, but you have to keep your time yourself. With that, please proceed.
Good morning. May it please the court. My name is Larry Charlotte, and I represent the appellant in this case, Industrial Park Center, DBA, Mainspring. The focal issue before the court today is the standard our state is applied to determine whether or not a loss is considered fortuitous within the context of an all-risk policy. It is Mainspring's position that the standard our state should apply is that which has been applied by virtually every jurisdiction that has considered fortuity in the last 50 years. That being a subjective analysis of what the parties to the contract, both the insured and the insurer, knew at the time that they entered into the agreement. Now, of all the jurisdictions, and I know the court has a bunch of briefs, supplemental briefs and the Ninth Circuit briefs. Of all the jurisdictions that have adopted the subjective approach, many of them have relied on Section 291 of the Restatement of Contracts. And as this court is aware, undoubtedly, in the absence of binding authority on point, and there is none in the state on this issue, this court will traditionally follow the restatement. And we believe this case should be no different. And with respect to 291, we submit that the plain and ordinary meaning of the language in 291, and as importantly as what it says, what it doesn't say, mandates that this court take a subjective approach in evaluating fortuity. Now, Section 291, as we know, addresses fortuity, and the way fortuity is defined within 291 is, quote, an event so far as the parties to the contract are aware is dependent on chance.
Mr. Charlotte, may I ask you, one of the things that, as you referred to the restatement section, you look at both parties' subjective knowledge, which kind of begs the question, well, what if they believe different things? And the state of knowledge of the insurance company would seem to be always, not always, but possibly less informed than the actual owner who has that kind of day-to-day knowledge. So how is that supposed to actually work when you talk about both parties' knowledge?
And there are 4 cases out there, maybe a few more, a few less, that specifically address when the insurance company has as much knowledge. It only comes into play the insurer's knowledge. When the insurance company has as much knowledge of a potential risk that they agreed to at the time that they entered into the agreement, that the insurer's knowledge comes into play. 95% of the time, the issue is solely what did the insured know at the time, which really is the primary basis for fortuity. Although 291 addresses, it says the parties to the contract. It's pretty much designed, it's not pretty much, it is designed to prevent intentional misconduct on the part of the insured. I hope that answers your question.
It does. It does in part, but it sure leaves a lot of concern about how it would operate under a real factual scenario. It automatically, every time you hear it's subjective, I start thinking, well, what if the owner is simply an absentee owner and doesn't really know, or even purposefully refuses to know really what's going on in the property that might be located in another state or another location? Is that then make it fortuitous versus the owner who is diligent and keeps up on what's going on with the property.
Right, and there's a case that speaks to that. It's a case out of Illinois, Johnson, something of America.
Yeah,
Johnson Press.
Johnson Press.
Johnson
Yeah.
Press, right.
Yeah.
And when you have this scenario, intentional misconduct can come in a number of different forms. It can come after the agreement is reached, and then a party, like in the University of Cincinnati Arkwright case, just deliberately destroys their property and then makes a claim. And then there is the Johnson case, where you can't hide your head in the sand. What happened in Johnson was it was a warehouse that had been abandoned for more than 5 years. The impression was it was much greater. And what happened in that case was that the warehouse became totally dilapidated. I mean, parts of the roof, and they had extrinsic evidence that showed that parts of the roof had been missing, the second floor had collapsed, the stairwell had collapsed, there was mold in the building for years. And then the insured enters into a policy, and then shortly thereafter, another part of the roof comes off and he makes a claim. And the court said, no, you can't hide your head in the sand. You knew when you abandoned this thing.
Well, that sounds like a should have known standard to me. Because again, under my scenario, take Johnson Press, the warehouse example that you just gave. If that owner had been across the country in another state somewhere and just owned the warehouse, but maybe didn't have that knowledge or purposefully refused to have that knowledge about the state of his warehouse and it collapsed, you said, well, you can't hide your head in the sand. Does that mean that sounds like you should have known? You reasonably should have known, even if the owner actually didn't know. So how do we reconcile that?
It does kind of sound like that, but what Johnson did is, and first of all, Johnson did not follow 291. It's not a 291 case. But what Johnson found was that, in fact, and it applied, by the way, a subjective standard. It wasn't a should have known. It applied a subjective standard and found, based upon the extrinsic evidence, that this insured knew what was going on.
Well, that insurer did, but I'm asking to say he didn't. Say the insurer, which in that case was a he, I guess, an owner, didn't know.
Well, that would depend in this hypothetical under a 291. At the time they entered, maybe I'll add a little bit to the hypothetical, but if at the time they enter into the insuring agreement for a loss and they're in another state and they haven't looked at this property in 10 years, more than 5 years, whatever, a sufficient amount of time where the property, unless it's maintained, is going to fall apart, I would suggest that the court will look at, under a 291 analysis, and even under the Johnson analysis, they will apply a subjective analysis and say, based upon the evidence, and that's how these few fortuity cases that are found not fortuitous come about. It's always extrinsic evidence that comes in. There's not the insured who says, I knew this was going to happen. I entered this agreement and I wanted a guaranteed payment instead of transferring risk to the insurer. It's never like that. It's always extrinsic evidence.
So to be clear, just in answer to my, I guess it became a hypothetical based on Johnson Press, your answer is that if the owner truly did not know subjectively, then it would be a fortuitous event.
If they truly did not know, and under a 291 analysis, it would be a fortuitous event.
It's another way to say this, that when an insured asserts that subjectively they had no knowledge, that the court is entitled to consider evidence to determine the credibility of their subjective claim.
You bet. And that's what, in those few cases, because for finding, as we know, this fortuity is a threshold issue, and it's a very light burden to prove I didn't commit fraud I didn't do anything dishonest. There are very few cases out there that find that a loss is not fortuitous. And all of those cases, Justice Lopez, they all rely on extrinsic evidence. The Cincinnati v. Archite, the Johnson case we were just talking about.
And the reason being that a subjective claim that is non-meritorious is a lie. It sounds in fraud.
That's right, and that's exactly what fortuity is, as the court is aware, is designed to prevent.
Well, and counsel, to that point, it seems too that, and I want to ask counsel for Great Northern this as well, that some of the concerns that we're expressing that have been expressed in the briefing too, doesn't that get sussed out during the negotiation over the policy in the first instance? I mean, if we're looking at any contest between subjective knowledge or awareness of the potential loss, the risk versus the loss, isn't that the basis for issuing a policy in the first place? So if we look at the Johnson Press hypothetical, if there is extrinsic evidence that shows that at the time of entering into the contract that the insured was aware of the status of the building, then they did engage in fraud and misrepresentation to enter into the policy. And it seems to me that
Right.
there's some degree of freedom of contract on the part of the insurer as well to verify the status of a building or something along those lines.
Absolutely. And in fact, in this case that we're here for today, there is evidence that annually GNIC would come out and they would inspect the suite, the Star Fishery suite where the damage was. And Justice Montgomery, to your point, there are four cases, I can't name them off the top of my head, but I think there are four, where the court said the analysis was just what you have just posited, that, look, insurance company, we all know you're not the little man in this bargain here, and you've inspected the property. You've got your own obligation. And if you know, go ahead.
And to be clear, we're not determining facts here.
I know.
I mentioned that because as we define what fortuity is, or what's fortuitous within this context, we need to keep in mind how that's going to be applied, so we provide sufficient guidance, not just to answer the certified question, but for future courts. To that point, I'm curious what your take is on the Attorney General's amicus, because I didn't see a response to it. Maybe you felt you didn't need to, because I'm curious about your position on what substantial certainty would look like if we use that to modify the test.
Right. Thank you for that. I thought for the most part, we did not file a response because we did not believe we needed to. We thought 90% of what that amicus brief said was spot on. And we did not respond to the substantial certainty. And if I could segue in with the Justice's question to the reasons why what is being proposed, whether it be almost certain, substantial certainty, or reasonable foreseeability, is unworkable for our state overall. Because we're not just looking at as you point out, the judge, I'm aware that we're not just deciding just this one case factually. It's what we're going to do for our state. And I would submit that if we were to apply a reasonably foreseeable standard or an almost certain or substantially certain standard, that not only would that frustrate the purpose behind fortuity, it would also frustrate the purpose behind insuring agreements in the first place. And I'll get to that in 1 second. And additionally, it's going to create, for the state as a whole, a boatload of uncertainty on what these words even mean. And I can tell you, as a lawyer practicing in insurance law north of 3 decades, I'm going to be real busy the next 10, 15 years if this court adopts that type of standard, because every insurance company is going to jump on board and see if they can't get a judge in hindsight to say, look, this was reasonably foreseeable. Why not take your shot? First of all, well, going back to the purpose behind an insuring agreement, why it it frustrates it, and it almost voids it. I think it's fundamental that all of us, everyone in this room, we will buy insurance for one of two reasons. We'll buy it because it's mandatory, right? You can't get on the road without it, or you shouldn't anyways. And secondly, you think that risk of loss might happen. It's reasonably foreseeable. If it's not, you're not going to buy insurance. You're not going to live in Phoenix and buy earthquake insurance. It's not reasonably foreseeable. And so if the standard is that a loss is not fortuitous, if it's reasonably foreseeable, it's basically going to make insuring agreements illusory if you take that standard. Secondly, frustrating the purpose of fortuity. Fortuity is about, as we discussed a moment ago, it's about intentional misconduct, right? And when you look at the language, which I was going to get into on 291, it says are aware, the parties to the contract are aware. It looks at what the parties are thinking, what they knew, what we've been talking about, subjective. To replace that, which is what the purpose of fortuity is, to look at what these parties knew, with an objective standard where you are going to replace that with a judge looking in hindsight, which again is something that happened in this case. I won't get into it. I know we're not addressing the specific facts of this case. But then the judge looks in hindsight and he or she determines what he or she believes is reasonable. That is entirely inconsistent with the purpose of fortuity, which is to look at the insured and the insurer and look at what they knew, not what this judge looks at 4 years later, taking into account a number of facts that perhaps the parties didn't know.
How do you, how would you assess whether someone subjectively knew something was certain to happen within the insurance period? Even in the warehouse example we've been using, it's a dilapidated warehouse, but how could the insured even be certain that it would collapse within that? I assume they had a 1 year period of their insurance period. So how do you assess certainty?
Right. So are you asking how the insured and insurer often at the end sound the same? Were you asking
Well,
if the insurer?
the insured, the person that wants the money.
Okay.
And this rather picks up on Justice Montgomery's question about the state in amicus saying it should be substantially certain. I think they were trying to get at that as well. What do we mean by certainty?
Okay. Certainty, and when we look at 291, the plain language of it says dependent on chance if we adopt 291. It doesn't say a minimum amount of chance. It doesn't say a significant. It says a chance. It actually makes it it gives certainty, because if there is any chance, it's fortuitous. If there's no chance, and therefore the loss is by definition a certainty, then we know it's a certainty. Substantial certainty, if I could, I know I'm on the clock. Substantial certainty and almost certainty. Not only, we're talking about giving guidance to the citizens and the insurance companies. What does that even mean? If you start looking at these cases, they're all over the board on how they define these things. And again, that's going to come down to a standard applied by a judge, which is going to open the floodgates to litigation, if I may.
Chief Justice Timmer said some words that I think are very important in defining fortuity, and they were within the insurance period. So suppose you have a retaining wall and your engineer comes in and says, you know what, that wall is going to fall. Don't know whether it's 6 months or 60 years, but it is certain to fail at some point. You have an insurance policy for 5 years. Is that still fortuitous if that wall collapses?
It is in that analysis. It absolutely is. If I could say one more, I hope I answered your question. One more thing before I attempt to reserve whatever seconds I have left. substantial certainty and almost certainty, I would submit to you that if you use that standard, you are going to void some valid insuring aleatory contracts, because some and substantial, that implies there's still risk. And the law doesn't place a certain minimum level of risk. If there is any risk that's being transferred, it's a valid aleatory insuring agreement. If I could reserve the last 22 seconds.
You make that.
Thank you.
23.
23. All right.
May it please the court, my name is Douglas Colladell, and I'm here representing Great Northern Insurance Company. And what I've learned is a very interesting issue that you would have thought over hundreds of years would have been more fully developed. And so we're looking forward to this court's interpretation and to help the court in reaching a conclusion about what standard to apply. We would suggest that the objective standard is what needs to be applied. Now, the restatement itself doesn't talk about how you find out about an insurance awareness. It doesn't talk about subjective versus objective viewpoints. Rather, there are some pundits that unilaterally said it's a subjective standard, and some courts have followed that. And we would discourage the court from just jumping into to doing that and really dig down into what is at hand. And we have certain principles that will help guide why an objective standard should apply to the assessment of the insurance knowledge in a case. And this court has come out before and said that insurance cannot be in the control of the insured. And so you can't have the insured with the single universe of facts that governs whether there is an awareness of a risk. You have to look at it from a reasonable perspective, like what do the facts really say? And to do that, I would suggest that that's a reasonable person's standard. You look at objective facts and make a determination as to whether the insured could have known or should have known. And there are many instances where this court has allowed the inference of knowledge. For instance, in a negligence case, there's inferred knowledge when somebody goes on a basketball court and throws an elbow, and it's a deliberate elbow versus going up and rebounding and accidentally coming down and injuring somebody with the elbow. There's an inference of knowledge when there's the intent to throw the elbow that's done, that's given to the insured.
But why should we put that level of knowledge, a reasonable person standard on someone who buys insurance? I mean, this is a contract at its essence. So maybe you're a completely uninformed, passive owner of something, and you really don't know and haven't done all the inspections and such. So you want to have insurance. I would think that, I read these exclusions that the insurance company comes out and says, well, we're not willing to take the risk or insure against the risks of, this, that, the other. Water damage, for example. I don't know if that happened in this case, but you could say, we're not going to insure any water damage done by a fishmonger tenant if you have that kind of a thing. And you come to an accord. Why is that wrong?
Well, if you look at it again from a public policy perspective, where you, again, don't put you can't have the absentee owner in a different state, as counsel said, put his or her head in the sand and not know what's going on. And to say that you do not have actual knowledge because you weren't around and you didn't do the things that you should have done, for example, basic maintenance on a property when there's information that there's deterioration occurring at that property, and you're just sitting in south of Florida enjoying cocktails in the sun and all that, while the property in Arizona is becoming more and more dilapidated because you don't do things. There's an inference of knowledge that should go. A reasonable person informed about what is happening back at the property would have undertaken regular maintenance. The absentee owner in Florida doesn't do that, but you can't insure for what the absentee owner should have done.
But I
And
think the
again,
question here is a little bit different. It's not the absentee owner, it's the owner who is there, but is seeking to insure against what might happen that he just doesn't know about.
Well, circling in, combining what Chief Justice Timmer's question was with yours, it's really the same thing, because if you have an owner here in Phoenix with property in Phoenix that is informed about a dilapidating situation, and again puts the head in the sand, that is something that an ordinarily reasonable person would not do.
Can't that scenario be caught up with a subjective test? I know that it's not your position, but there are sub-principles of known loss and loss in progress. Doesn't that capture what your concern is?
I don't think completely, Your Honor. I think the difference is that you may have a loss in progress and you may not have a loss in progress, but something that is occurring that would put a reasonable person on notice and make them aware that it is no longer a risk, but it becomes a substantial certainty or almost certain that the condition would happen. It's not a progressive thing. So you can have a situation where, yes, there's a progressive one that they should have known about, but also something else that leads to an immediate occurrence.
Well, counsel, on that point, this is to follow up on what I think Justice Bean is asking. How do we make a distinction there between the position you're putting forward and somebody who builds a home in a floodplain or in a national forest? Certainly, you can look at that property being flooded. Certainly, you can look at that property being burned down. I think the position that you're taking in the test you're asking us to adopt, I mean, that those aren't fortuitous losses. You could reasonably foresee that, yeah, you build it in a national forest in drought conditions, it's going to burn down.
Well, I think there are cases, Your Honor, I don't have them off the top of my head, but situations where you do live in a flood area, say in New Orleans, where you have levees that could not hold back water, and you know from hurricanes that that's a likely certain to occur event, that flooding. So it would not be fortuitous to experience flooding when you're in that zone. What we have here, I think, is a little different, and you have a situation where you have water damage inside of a building caused by ongoing issues.
Let me press pause for a second, because I'm not quite sure you made the distinction I was hoping for. Because in those two circumstances, we're just sticking with certain that flooding can occur in the levee area. It wouldn't be fortuitous. So that means then that if the insured contracted for coverage, that the insurance company would be able to deny that coverage? Because that was not a fortuitous loss.
I think in flood insurance, you get into a bunch of different situations that I'm not really specifically sure about. But
So we should impose a standard here and says this covers everything except for flood loss.
No, but the analogy that I was going to make with the building, where you have a situation like the insured in this case is informed 12 years before the policy incepted that the stairwells are dilapidated, the concrete walls are failing, and they're crumbling. And so that is different than a situation where a pipe bursts. Both have water damage, but the pipe burst was not foreseen by anybody or reasonably foreseeable. It was an accident. It was an occurrence. It was something that could not be explained and thus insurable. It was a risk insurable.
Does that mean that you, under your position, that you cannot get insurance for reasonably foreseeable risks?
No, what I'm saying is if the risk, in a way, yes. If the risk itself was reasonably foreseeable when the insured and the insurance company contracted for that insurance, then it's not really a risk. It's not a fortuitous event. It's something that's going to occur.
So let me
likely to
give
occur.
you a hypo. You have a baseball player who has an elbow injury, and the recommendation is to get surgery. And the insurer insures an all risks, provides an all risks policy. The player says, you know what, I'm going to play through this, and blows out his elbow. A really high risk that is going to occur, but not certain. Uninsurable?
It becomes uninsurable when it gets to the point where you have 99%, maybe 100% of the pitchers in the same situation that continue to play for another year or so, and their arms blow out. The decision not to get the surgery that would have corrected the medical problem and allowed for future pitching, that is then not a fortuitous.
Well, it seems to me that really would invalidate a lot of insurance policies. Health insurance, where you're covering a group, you know that some of those people are going to be sick. Whole life insurance, you know they're going to die at some point. Can't the insurance company take those things into account? There's even insurance for people who live by the levees in New Orleans. It's, I assume, very, very expensive.
There's a way to underwrite, all sorts of situations. And when you have health insurance or you have life insurance, you have, they have underwriting protocols that they follow to do that. But when you put it into the commercial liability context and you have a particular risk that's at hand, if you're going to underwrite for what is just within, you can't objectively implement those underwriting principles to assess the risk on a global scale. And so what you're doing then is then you're encouraging higher premiums to cover potentially unknown to the insurance company.
Or exclusions.
Well, but you have, again, if you have to anticipate what knowledge a particular tenant or insured might not have. There are wear and tear exclusions that are in place in this policy. But also when you go to look at fortuity, one of the things that courts look at is ordinary wear and tear. That's not a fortuitous event. So if you are not maintaining your property against ordinary, circumstances that arise from ordinary wear and tear, then it's not a fortuitous event. It's similar to what occurred in this particular case. And so,
to that point, it seems to me that if you're going to have particular wear and tear exclusions, it's going to be because, and so this gets to the question that I asked opposing counsel to begin with that I said I was going to ask you. At the point of negotiating the policy and determining what exclusions may apply, isn't there, some sort of an obligation on part of the insurer to take a look at what the property is or to have some sort of assessment of it so that you can figure out what that risk is?
They do, but they also don't have, in making that assessment about whether to insure or not, or how to insure that particular property for a particular premium, they don't have the subjective knowledge.
But can't they
insured.
ask the insurer what their knowledge is at that time, or the insured? Can't the insurer ask the insured, what is your knowledge of the state of the property at the time? Can't they ask those questions at the time of the policy being issued?
But again, that's a general due diligence question that ties into Justice Montgomery's question as well. But to have to ask an insured about every possible, issue in a building. Are you aware of any potential water damage? Are you aware of soil issues? Are you aware of, and just go through a laundry list of possibilities that don't appear from an ordinary, view of the property, it looks fine, and yes, you are counting on the insured to provide information about what they know.
But you're not just counting on them, because what if they give a false information? What if they give false information? I think, first of all, the insurance company is well prepared to create long-form contracts and questionnaires in terms of assessing risk. So wouldn't that be a basis to deny a claim if you had questions about the condition of a building and the insured's awareness of various types of degradation or problems with a building? If they answer in a way that is untruthful, wouldn't that be the basis to deny the claim, and wouldn't that protect the insurance company?
Yes, there would be fraud. Yes, that would be a basis for denying the claim. But when you're talking about, assessing fortuity from a perspective of whether it should be a subjective test or an objective test, that I don't think really enters into the equation. What you're looking at is what's the knowledge that would go down onto that piece of paper. And what we're saying is what you have to disclose and what you have to talk about in terms of assessing fortuity is an objective standard that can be reasonably tested, not just within the hands of the insured, which could lead to what you're alluding to as potential fraud. And so you have the public policy reasons why it should be an objective standard, something that is more easily assessed, more readily applied across the board, and not just to a particular person's subjectivity.
Counsel, excuse me, let me ask you this particular question. Let's say that a majority of this court rejects objective foreseeability, and we're going to go with the restatement provision. What would you want us to do in modifying or clarifying the restatement to minimize the ability for an insured to engage in the kind of conduct you're concerned about?
Well, I think, Your Honor, again, it's to follow what this court said in Barnes versus Outlaw, which is we can apply the restatement, but we're not going to do it blindly. So I welcome the question about what do we do, and that's to institute a policy regarding fortuity that does not allow the insured to control the outcome unilaterally. And the court has come down on that, before. It allows for what the state, basically was saying was, substantial certainty. And the state also agreed that there is a reasonableness standard that comes into play when there's a dispute about the insured's actual knowledge. So the state, I think, is in agreement with the standard, other than calling it a subjective test versus an objective test. We say objective, they say sort of subjective, but not really when it's a situation of substantial certainty and the insured's knowledge and awareness is in dispute. So that's really an objective test. So there has to be some kind of accommodation for reasonableness application of the restatement, section 291.
Thank you.
And in part, my colleague over here was talking about the need for extrinsic evidence. Again, if you're going to look at extrinsic evidence, then that brings into play an interpretation of what that evidence is. And so that interpretation, which is going to be made by a judge, it's a legal question, fortuity is, the guidance for the judge making that determination is that there has to be some kind of a reasonable application of the facts to the situation and to whether or not there's coverage, whether or not that situation is fortuitous. So again, I think what we hear today is a lot of, well, it's really a subjective standard that applies. And it's not. I think it's a lot more nuanced, as Justice Montgomery, you were saying. And for that reason, we think just generally an objective standard should be applied. But if a subjective standard and awareness focus on the insured and the insured's knowledge, then you have to take into account those other situations that we just mentioned. And I think unless the court has further questions, we would submit.
No, thank you.
Thank you very much. Not that I had any more time left.
You did save 8 seconds, so that's something.
That is
How professional of you.
I love the comedy here.
So, Mr.
I think I can do this in 10 seconds. But optimistic. No state or jurisdiction, whether it be a state court or a federal court, has ever applied an objective standard to fortuity. This would be the first state to do so. For all the reasons stated in the briefs, the appellant's briefs, and here at oral argument, we would request that the court provide a standard for fortuity consistent with Section 291 of the Restatement of Contracts and the case law interpreting 291, which is all subjective. Thank you.
Thank you. Thank both counsel for your briefing and your argument today. Advisement and issue a decision in due course. We will recess to allow a change on the bench, and we'll be back.